Federal bond claims and state bond claims are very, very similar. So we'll go over both of them, but just note in your head that there's only a couple of differences between the two. The Miller Act provides protection to subcontractors and suppliers on federal jobs. On federal jobs, payment bonds are required for any contract for the construction, alteration, or repair of any public building or public work. The bond must be in the amount of the contract. No liens are allowed to be filed against the federal property, meaning that subcontractors or suppliers must look to a payment bond for satisfaction of their claim. The Miller Act only reaches suppliers to the prime contractor, first-tier subcontractors, and second-tier subcontractors. Second-tier materialmen and third-tier subcontractors are not covered. So you have to kind of find out where your client is in the list, and if they are second-tier materialmen and below, or if they're third-tier subs and below, they cannot make a claim under a federal bond claim. So normally, if we go under like the normal mechanics lien laws, you're giving upstream notice. But under a federal bond claim, you're not required to give upstream notice unless you are a subcontractor, and then you must give it to a GC. And you have to give that notice within 90 days from the date you last performed the labor or furnished the last of the materials for which the labor or the claim was made. So, as an example, if you are a sub and you contracted with the GC, you don't have to give any kind of notice. So if you're a sub and you contracted with someone down the line, they are the ones that have to give the notice to the GC. So just to make it simple, that's the only person that has to give the notice under a federal bond claim. If you have to give the notice, though, you have to include the amount claimed and the name of the party to whom the material or labor was furnished and supplied. So you have to name the sub that you provided the work to or the material to. Under a federal bond claim, a suit can be made. They have something kind of different. There's a date in which you have to pass before you can file suit. And the suit, you can be made no sooner than 90 days after the last of the claimant's work is done. So you have to wait 90 days after the work is done. And then you can file suit no later than 1 year after final completion of the work. Just to note, that suit would have to be brought in the federal district court, wherein the district of which the contract was performed. There is a final completion requirement, and it is very, very vague. So we talk about warranty work again. Warranty work, repair, or inspection work will not extend the date for bringing suit. Warranty work comes after final completion, but what if the inspection reveals contractual obligations that have not been met? At least one case has held that the time to sue was extended until the contract was completely performed. So I would honestly not rely on this. I, again, would, take it for, what it's saying, after the 90 days, but within the 1 year. I would not try to mess with final completion and that type of thing. What about the attorney's fees and on a federal bond claim? believe it or not, they are silent as to attorney's fees. It goes back to common law and says, well, you know, if there's whatever your claim is under has a contractual basis for attorney's fees, we're going to let you do it. So, you know, if your claim is basically based on a breach of contract and your state allows for attorney's fees for breach of contract under, you know, a common law claim for breach of contract, then they're going to let you do it under that. What about interest? It's the same thing. They will consider the state law as a guide to the interest, and if the state law would allow you to obtain or be awarded interest, then they are going to let you get it under the state law. All right, so next thing we're going to go through is the state payment bond claims. Liens are not allowed on public lands. So a different scheme involving liens against bonds have been developed. A prime contractor, we talked about this before, is one who has a contract directly with the governmental body. So on this particular situation, the prime contractor contracts with the government, and they must furnish a payment bond for the benefit of the subs and the suppliers on downward. And the performance bond, I guess you might have probably heard that there's a payment bond and there's a performance bond. A payment bond is an actual amount that is used to protect subs and suppliers down the line from the prime contractor, and that's just if they don't get paid, they can try to go and get paid from this payment bond. But the performance bond protects the governmental owner if for some reason, like the general contractor, the prime contractor walks off the job, for instance. They use the performance bond to find somebody else to do the work, and they use that money to pay that person. So that's the difference between the payment bond and the performance bond. So if you have to file a bond claim and you ask your client for, give me a copy of the bond, and all of a sudden they give you both of them, a payment bond and a performance bond, you don't need the performance. Just throw that away. You just need the payment bond. So the performance bond, there's probably never going to be a situation where you need that to help you in collecting any funds anyway. Since liens cannot be filed on a public property, the best source of protection for subs and suppliers of public work prime contractors is perfecting a lien. When work is performed on a state construction project and not paid, a lien can be filed against the project pursuant to what is generally called a Little Miller Act. So if you'll recall, when we were talking about the federal project, the federal statute was the Miller Act. And so most of the states call their statutes the Little Miller Act. So I have the statutes listed in your paperwork, but almost every state has a statute that they refer to as the Little Miller Act. And so the purpose is that they use the federal Miller Act as a guide for the Little Miller Acts. So we got the federal statute for federal bond claims. We have the state statutes, which, you know, mirror the federal bond claims, but these are for state property. So they're very similar. They look similar. They have similar attributes. They have similar names, you know, the Miller Act, the Little Miller Act. But in every state, the statutes will be, you know, obviously different. It's from a state statute that gives you the rights under that statute. Almost every state has one. Since the claim is not against the state or the county's actual property, but instead is against the posted bond, the claim is not really called a lien, but it's more frequently referred to as a bond claim or a Little Miller Act claim. The amount of the bond the prime contractor is required to provide is the amount of the prime contract. So whatever the prime contract is, that's the amount that's usually the bond is made up of. The amount of the bond limits the amount available to claimants who properly perfect their bond claims. So I don't really see it too much in state bond claims where they're more than the bond amount itself, but it could happen depending on change orders, that kind of thing. If the total claims exceed the limit of the bond, the claimants who perfected their claims share pro rata. So that's the same as what we did when I showed you the retainage. They will add up all of the claims and they will divide them out pro rata of the amount of bond. If a public entity fails to ensure that a bond is secured by the prime contractor, the entity may be liable to the same degree that a surety would have been had the surety issued the bond. So like I said, I've not really seen that, but it does seem like that, claimants are sufficiently protected in this situation. I have gone through and kind of given some references to various states of what their Miller Act, their Little Miller Act states are for their statutes. You can just do a Google search for Little Miller Act, what your state is, and I guarantee it will show up. And you can read up on it, but it's going to be very, very similar to what we're talking about here. The following situations have been tested in various courts and have been deemed covered by the bond. Labor paid out on a commission basis qualifies. Where labor is furnished by a temp agency, then the temp agency qualifies to make a claim on the bond. A few examples are that have been deemed not covered by the bond. Plans that were provided but were never used on the construction project, not covered. Insurance premiums that were normally held, such as workers' compensation and liability coverage, not covered. The courts have distinguished between materials that may or may not qualify, and the following has been upheld through the courts. Materials that the courts have found to qualify include items that might be rented or leased for a job that are off-site, such as a rock crusher located at a quarry that could not be moved to the actual job site. One could also claim a leased piece of equipment that will be used exclusively for a specific job and then returned when the job is complete. However, the courts have stated that materials that might be purchased and used in the normal course of business for a construction business are not allowed to be claimed. So these sound an awful lot like the specially fabricated materials that we saw before, kind of the same test. If they were purchased and you can only use them for that site or that project, they're going to qualify those.